Okay, we'll just come to you in a moment because right now it's a historic moment. The Supreme Court is delivering its judgment in the demonetization case. Let's cut across.
Thereof, to accept the demonetized notes beyond the period specified in notification issued under subsection 1 of section 4. Insofar as the first issue is concerned, we have considered the judgments of constitution benches in the cases of the Chief Inspector of Mines versus Lala Karamchand Thapar and Banwarilal Agrawal versus State of Bihar. And the third one, Tej Kiran Jain and others versus Sanjeeva Reddy and various other judgments of the various bench strengths, wherein word any has been interpreted. And it has been held that the word any has to be construed in context to the statutory provisions. And then the second principle which we have considered is the purposive construction. We have referred to the Constitution Bench judgments in the case of M. Petia and others. Then Chief Justice of Andhra Pradesh versus V.A. Dixitilu and others. And Tinsukia Electric Supply Company Limited versus State of Assam, apart from the other judgments. We have held that the modern trend is of pragmatic and not pedantic interpretation. The interpretation leading to absurdity and which renders a provision to be futility has to be avoided. Any interpretation which advances the purpose and object of the legislation has to be preferred when two constructions are possible of particular provision. And applying these principles, we have held that a restrictive meaning cannot be given to word any. And insofar as issue number 2 is concerned, we again refer to the Constitution Bench judgments in Hamdard Dawakhana, Tharakchand, Ratanchand Bantia, and Birla Cotton and Spinning and Weaving Mills. We have held that for finding out the policy and guidance, a resource can be held to various provisions of the Act, including the preamble, the purpose of the Act, and what is necessary is that the parent statute must consist of an essential legislative function, that is determination of legislative policy, and it is permissible in view of the multifarious activities that it is necessary for the legislature to delegate the working of details. When we have considered the status of the RBI, we have referred to the judgment of the Constitution Bench in Joseph Kurila, then the judgment authored by my learned brother Justice Ram Subramanian in Internet College. And we have specifically emphasized on the primary role of the RBI in issuance and regulations of banknotes, then its important role in monetary and economic policy of the country. Then we also consider the nature of body to whom the delegation is made. In the present case, the delegation is made to the central government, which is answerable to Parliament, and Parliaments are in fact answerable to the citizens of the country. In this respect, we have referred to the judgment of the Constitution Bench in Birla Cotton. Then in the case of Harachand itself, when clause B of subsection 2 of section 5 was held unconstitutional, in the very same judgment, the Constitution Bench has held clause A of subsection 2 of section 5 to be constitutional on the ground that it provided that the administrator can take action after consultation with the RBI, and therefore there was self-imposed provision which required the RBI to be taken into consideration. Applying the same principle, we have held that in the present case also, the central government is required to take the action after recommendation of the central board, and therefore there is an inbuilt safeguard. Insofar as third issue is concerned, we have basically relied on the judgment in the case of Tata Cellular, wherein the scope of judicial interference in matters pertaining to is very limited. Then we have further referred to various Constitution Bench judgments which are specifically dealing with interference insofar as economic policy is concerned. The judgment in Prague Ice and Oil Mills versus Union of India rendered by 7 judges. Then R.K. Garg versus Union of India. Then Sri Sitaram Sugar Company versus Union. And which has been held that there has to be a great deal of restraint insofar as interference in the matters pertaining to economic policy is concerned. The court cannot substitute its judgment for that of the legislature or the executive. It does not supplant the feel of the experts with its own views. Then we have also scrutinized the record, and after examining the record, we have found that the judicial decision-making process cannot be flawed merely because the procedure has emanated from the central government. We have construed that the term recommendation has to be construed in the context of the statutory scheme, and what is contemplated is a consultative process. And from the record, it appears that there was a consultation between the RBI and the central government.
All right, we'll wait by as the Supreme Court delivers that judgment in the demonetisation case. For the time being, let's focus on a couple of stocks. Well, SCI is reacting to a piece of news that we put down